All right, everybody. So we have about a half hour before Jessica starts her weekly live Zoom. So we're gonna go into a couple of things here before that, and if you guys want to break off and participate in that, understand what we're doing a little bit better with regard to the service to the county commissioners, city council, then I would welcome you guys to do that. That's at 3:30 Central, 4:30 Eastern, so that's in about a half hour, okay? So, again, there's been some question about the litigation that we've got here. And we need to remember that I'm not fighting for indictment by a grand jury and the absence thereof. That's not the heart of the issue. The heart of the issue is jurisdiction. Does the state have jurisdiction to oversee the disposition of a dispute in which the state itself is a party? And the answer is absolutely not. Absolutely not. This is constitutionally codified in Article 3. All right? And this goes back, to the founding of our country. Like the very first case that the United States Supreme Court ever heard was a case called Chisholm versus Georgia. And this issue was effectively litigated by Chisholm back then. This was 1793. This issue has already been addressed. It's already been litigated, and yet we're having to do it again. We have the same argument and the same issue, but the provision has been bastardized and taken out of context, and the government has decided that the provision doesn't apply to them anymore, right? And so when these states continue to say that the Bill of Rights doesn't apply to them, they're not respecting the Constitution of the United States of America. They're not respecting the Union. They're not respecting what James Madison conceived with three separate but equal branches of government. The Bill of Rights absolutely is a restriction against the states in the same way that it's delegated power to the central government, and that's codified as well within the 10th Amendment. 10th Amendment says that rights not delegated to the central government nor restricted by this to the state governments are reserved by the people of the states respectively. The Constitution provides restrictions. If that weren't true, then the 10th Amendment wouldn't apply to the states either, right? Because the Bill of Rights wouldn't apply. This argument that they're coming with, it's not a winning argument, and they're not going to prevail on it. So jurisdiction is the heart of the issue that we're litigating. And let me lay it out like this, okay? So the Constitution of the United States, again, is the overarching requirements that every state must follow, right? States cannot enact their own alternative legislation and substitute that for the guarantees of the Constitution and then go out and enforce that as though that's constitutional. That's clearly unconstitutional. State laws are not more powerful than the Constitution of the United States of America. So when the Constitution under Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, that's clear, right? Anytime that a state chooses to become a party in the cause, and it doesn't say the position of the party either. It doesn't say respondent or petitioner, mover or defendant. It says in all cases in which a state shall be party. So remember, there's two parties in every single case. It's identified by the case itself. There's a moving party, a petitioner, and a responding party, a defendant. If the state chooses to take a side, either side, then the state loses its ability to be able to oversee the disposition of that dispute. This is a very, very simple concept. So why is that? Guys, in order for a court to render a legally binding decision, it must have two things. Must have both. The first is it must have subject matter jurisdiction, which is the right to oversee the type of case that is brought before it. So for instance, in the case of a death, you wouldn't bring that to a small claims court because they wouldn't have subject matter jurisdiction to oversee the disposition of the deceased assets. You would bring it to a probate court because that would be the court that would have subject matter jurisdiction. The second thing that the court must have is it must have personal jurisdiction, which is the right to oversee the parties involved in the dispute. Personal jurisdiction is codified in the Constitution. It is statutorily imposed. No man can oversee their own dispute. This is a very basic concept. So how can the judge be the same body of men that represents the accuser as well as also the one profiting off of the involuntary servitude once the individual is sent into a for-profit business for the direct benefit of state, once they're placed into incarceration? The judge cannot be presumed to be impartial, and that's why our founders wrote Article 3 the way that they did. So if the court lacks either subject matter jurisdiction or personal jurisdiction, we're not going to go into territorial. We don't need to. But if the court lacks either one of those two things, subject matter or personal jurisdiction, then what that court produces is void, fully, without force or effect on the parties involved in dispute, because any court that lacks jurisdiction cannot obtain jurisdiction. Remember, you need to look at the time or the chain of events. We, the people of the United States, in our sovereignty, created the Constitution. The Constitution then created jurisdiction, which is the power for a court to speak the law. Jurisdiction then creates the court, and the court then creates the court's agent. So absent jurisdiction, the court isn't a court. It has no authority to be able to oversee the disposition of that dispute, which is why a judgment or a court that acted without jurisdiction, what it produces is void. Refer to Civil Rule 60B4, okay, 60B4. Now 60B4 is interesting because it says that a judgment is either valid or void. It can't be anything else. It's either valid or it's void. And it says that it is void in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, then the action, the judgment is void, wholly without force or effect, which means that judgment can always be challenged. It never becomes valid, right? Because a judgment that lacks jurisdiction or court that lacks jurisdiction that makes a judgment, that judgment can never be valid over time or by subsequent legislation, return to the maximum of law, okay? Any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. So it doesn't matter what the court produces, right? What matters is whether or not the court had the lawful authority to be able to produce it. And as of this moment, they do not. And that's the heart of this litigation that we're bringing up. Yes, it includes absence of the indictment by a grand jury. It does. It also includes family court and all these children that are being taken from their families under these CPS systems. Yes, that includes part of this litigation. But what you guys need to understand is the way that we're fighting this is that we are going to void the action of those courts. A lot of people are asking me, how does the indictment by a grand jury tie into family court? And I've explained this a number of times, but clearly you guys still have questions, so I want to explain it again, all right? How does the absence of the indictment by a grand jury tie into the family court and the interference with the familial unit? Well, this is how it works, right? Because if I can successfully litigate the fact that more than 700,000 people are currently imprisoned here in America on direct facial constitutional violations because the states, every single one of them, have failed to follow the very basic procedures and processes codified in the Constitution for the adjudication of a crime by failing to have the indictment by a grand jury, then the issue or the question that we have once again is, can a state be both accuser and judge in the same cause? And they can't. So the same thing would apply to your family court issue. CPS is an agent of the state. We got Jessica here, guys.
Hi, guys.
I got Jessica here. So, and by the way, she's about to go on in 15 more minutes. So I told you guys that if you guys have, you guys want to get in and work with her, listen to her. She's going to be going over the city council and county commissioner stuff. You get into the camera here.
Trying to get into all of them.
So she's going to be going over the county commissioner services, city council. I want to talk to people a little bit more directly about the litigation and those questions that you might have about how this interrelates with family court. Okay, so once again, if the state does not have the constituted authority, the lawful authority to be able to oversee the disposition of a dispute in a criminal matter, right, when the state took a side in the case by bringing the accusation through one of its agents, then the same can be said in family court as well. And so when the CPS being an agent of the state, and we know that they're an agent of the state because one, they're paid by the state, two, they claim immunity from the state, and three, right, they are enforcing the laws of the state, they're absolutely an agent of the state. So when an agent of the state brings an accusation against you or your family, then the same body of men that make up the state, being the judge, cannot be presumed to be neutral and biased to act as the judge in the case to oversee it, right? This is a very basic conflict of interest principle. And so if we can effectively litigate the absence of an indictment by a grand jury, we will absolutely be able to litigate the same issue on the family court and be able to restore, your children, because the way that it must work is that once a judgment is rendered void, they must return the individual to the point in which the rights were deprived, right? Or the act of deprivation that was done unlawfully. I can't tell you that that's the way it's going to work, but I'm telling you that's the way it's supposed to work. So once it's deemed that the judgment or action of the court was void because the court lacked lawful authority to be able to take action, then they must return the parties back to the point of the breach of constitutional obligation. And that would include, an adoption. If they adopted your child out, right? Remember, that adoption is secondary. It's the result of an unlawful removal. So if the removal was unlawful because the judge didn't have authority to do it, then that would mean that the adoption, which was secondary to it, would also be void, right? So even if they did that, you would still have to. So Jessica's here. I want her to. Jessica has a question.
I have a question.
For me?
Yes. For
Oh my goodness.
Can you tell everybody how the county commissioner services are so important to this movement, both for the unlawful arrest as well as for the unlawful removal of children?
Yeah. So remember, what we're doing now is we are trying to tie the legislative branch into all of this. We've already gone through and we've already served the Attorney General, which is the executive branch, right? We've already gone through and we've already served the Supreme Court, which is the judicial branch. But now, in order to get this into the final stage, into the United States Supreme Court's jurisdiction, is we must put the final branch of government on legal notice. Give them an opportunity to cure and rectify the problem. If they want to fix the problem, awesome. Then there's nothing to litigate. There's no dispute. But in order to move into the Supreme Court, United States Supreme Court's jurisdiction, we must provide formal notice, which is why when Jessica opens up or other people open up for me, they say this is in accordance with Rule 17 and Rule 20 of the United States Supreme Court, because Rule 17 and Rule 20 is one, original jurisdiction, because as I said, we're invoking original jurisdiction of that court, and two, providing proper notice to the offended part, to the opposing party. That's what we're doing. The states are in opposition with the people because the states are refusing to enforce the body of laws that the people created and that govern them. So my point is that we had to find a way to make the legislative branch be tied into this, right? It's easy to point out how the prosecuting attorney is bringing the incorrect charging instrument, right? By bringing information as opposed to indictment. It's easy to say that the judge is engaged in a criminal conspiracy when they rely upon the prosecutor and hold someone over without having the indictment by grand jury. Those are easy. Those are the first two branches of government, those are easy. But what's not easy is the third branch, which is the legislative branch, because they aren't in the courtroom. They're a separate body. That's why we're using the emolument clause as the mechanism to force them to actually have some skin in the game. Because it is a crime to pay someone to break the Constitution. We all know that. And we're talking federal Constitution as well, because these states are receiving federal funding to fund their justice system. So this isn't just a state emolument, this is a federal emolument. If you receive federal funding and then you pay someone to abridge federal obligations, that's a pretty serious crime right there. Go ahead, I'm sorry.
No. Explain how emolument is just an old term that we're just bringing up now.
Yeah, so the maxim of law that emolument derives from is that no one can profit off of their illegal acts. Right? You can't profit off your illegal acts. If you're committing a crime, you can't profit off of that crime. Right? That's a very simple maxim of law. So the emolument actually derives from that particular principle, is that if you pay someone to commit a crime, that person is profiting off of their illegal acts. Emolument is a term that was used, at the birth of our country, at the beginning of our country, very, very regularly. It's not one that we hear a whole lot today because all of our politicians are all property not particularly lax. There is absolutely no denying, that. Not only that, but they also make us stand up and call them honorable when they walk into the courtroom as if they're fucking crazy, I mean, these people don't understand, that they are the cause of the destruction of this nation, and we're bringing it to their attention. These legislators, these state legislators, they are all responsible for the inferior state law that permits or directs that prosecuting attorney or that judge to abridge their constitutional obligation. Those legislators are responsible for it, right? How are they responsible? Because they create the laws. Remember sedition. This is a very, very a common word that we're hearing a lot today, especially from the administration, right? Sedition. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. So basically what it means is that if you create a law that is altering the Constitution in other than lawful manner, that is the very definition of sedition. And every one of these state lawmakers, whether they know it or not, willfully or negligently, it doesn't matter. They're responsible for the seditious laws that exist that are undermining the laws of the United States and directing agents all across the states to abridge their obligation.
But it doesn't have to be lawmakers. It can be your judges too.
Absolutely,
the judges
because
are doing the same thing.
Especially when the judges call their rulings law, right? Judges, this is a big part of what we're arguing here, is that judges can't create law. That's a separation of powers issue. All legislative power is vested in the first branch of government, the legislative branch. So when a judge creates a ruling and then calls it law, well, that's unconstitutional, my friend. And that means that you've spoken words, right, intended to cause disaffection to the Constitution so you can procure the alteration in other than lawful manner. The Waite Court, right, the Taney Court, the Marshall Court, United States Supreme Court, all of them are traitors. Traitors because they spoke seditious law that has amended the Constitution in an other than lawful manner. Take, for instance, Chief Justice Waite. Chief Justice Waite decided that he was going to say that the indictment by a grand jury is not required. California, you don't have to do it. And in making that ruling, that he erroneously and unconstitutionally called law because he overstepped the separation of powers, decided to legislate from the bench that said, you don't have to do what the Constitution explicitly states that you must do, California. In doing so, he spoke the law that was intended to cause disaffection to the Constitution to procure the alteration of it in an other than lawful manner. The Supreme Court of the United States has no constituted authority whatsoever to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic and explicit act of people in accordance with the special amending procedure of Article 5. No other way to do it.
There was a question about if we've served Louisiana legislators.
We have not done a parliamentary service in the state of Louisiana yet. We have served the Attorney General, and we have served the Supreme Court of the state, but we have not made it into Louisiana yet for a parliamentary service. And that's what I'm calling these, is parliamentary services, because, that's just the easiest way. So when I speak of parliamentary services, I'm referring to a service to a parliamentary body, which would be city council, county commission, or the state
Like a
senate.
committee?
Yeah.
A committee?
Yeah. So the committee as well. The thing is that the notice, once made aware of an unconstitutional act, remember, notice to agent is notice to principal, and notice to principal is notice to agent. So when we went into Georgia, for instance, and we went to the Senate Public Safety Committee, and we spoke on this issue to the Public Safety Committee, yes, there were only 4 senators in there, but those 4 senators are all sitting members of all agents of the body. Therefore, the moment that we informed one, we informed them all. It's their obligation to take action. So notice to agents, notice to principal. We don't have to inform every single one of these senators or congressmen, but so no, we haven't done Louisiana yet. There are quite a few states that we still have not done a parliamentary service in. as of this moment. Yeah.
Okay, can I do a Zoom plug?
Yeah, please.
All right, so we have a Zoom. There's a lot of people that were on there when I left to come down here. Go to justicewithoutlimits.org. You guys see me? I put the Zoom link at the front of the homepage. If you haven't signed up, I would prefer you to sign up so that you get my emails in case something happens or something goes down. All of the emails are being moved into a safe, secure folder. So if the website goes down, if our social medias go down, whatever, we can still have contact with you guys. We have almost 10,000 people on that email list. So
Say the website again, or someone type it in too, please.
Yeah, if you guys are on here, please type in the comments, justicewithoutlimits.org. The Zoom link to get on is there. I sent the emails out. If you have registered or you've signed up to get the emails, I sent that out about 2 hours ago, but justicewithoutlimits.org. So the Zoom that we're doing today is going to be a little bit different. I have almost 20 breakout rooms. We're going to meet in individual rooms based on location. It's going to be based on the federal districts 1 through 11, and then some of the hotspot cities, including cities in Florida, East Tennessee, Maricopa County, Arizona. That's a freaking huge one. Even though we already served Maricopa County and we served an affidavit. Now that we have almost 50 people that can go back and serve more affidavits of criminal conspiracy, that's what we're trying to do. So it's going to take a lot of coordination, but that's what this Zoom meeting is for. I'm getting ready to go back on there. We're supposed to start here at 3:30. So that's where I'm going to be. Go to justicewithoutlimits.org. The Zoom link is there right at the top. Just log in and say hi. That's it. That's it for me.
Okay.
All right. Thank you. Bye, guys. Love you all.
So her Zoom is not available after this. This video will be available. So if you guys want to jump off and get on with her, I would highly recommend you do that, because you will not be able to review her meeting, after the fact. You can with this. So any of you who are on here, this video is being streamed, I think, to like seven different places right now. So you guys can watch it again on YouTube. You guys can watch it again on Facebook. You can watch it again on Instagram. Any one of those. So if you do want to get up with her, then I would highly recommend you do it. Just going back to what we were saying there is that, the reason why we're doing these city councils and county commissioners, again, is because we must notify the legislative branch. We must provide that service to that branch of government. There's 3 branches of state government, right? Executive, judicial, and legislative. And in order to properly provide service so we can move into the United States Supreme Court's jurisdiction, we've got to provide notice to all 3 branches. That's what we're doing. That's what this is all about. Hey, do you want this one? I didn't mean to bring them down. I'm sorry. I didn't mean to do that. No, leave one for me. No. Anyone? No? Okay. Love you. All right. But again, the whole point was to tie the legislative branch in. All right. We needed to get the legislative branch so that they were served as well. And if you think about it now, right, remember, notice to agent is notice to principal, but notice to principal is notice to agent. So when I went and I served the Vermont State Attorney General, for instance, when she was informed of actual crimes that are being committed by her prosecuting attorneys and police officers, because she's the highest law enforcement officer of the state, right? When she was informed of the situation and she failed to take action to correct the unlawful acts of her agents, then all of her agents have been served. Notice, all of them. We don't have to go and serve another police officer in the state of Vermont or another prosecutor in the state of Vermont because we notified their boss, right? Notice to agent is notice to principal, and notice to principal is notice to agent. If the unlawful acts are not corrected by the principal, then the unlawful acts of the agents are accepted, and now we don't have to inform anyone else. All right, now my point is that in the case of the state of Vermont, now that we have served the highest law enforcement officer and they failed to take action to correct the unlawful acts of their agents, that means that every single agent is now opposing party to this case, right? There isn't a single, the state attorney general, nor her deputies, nor a prosecutor, no one within the state of Vermont in law enforcement could represent the people on this issue because they're all now opposing party to the people on this issue, right? And same thing can be said when we serve the state Supreme Court. There is no court in the state of Vermont that can oversee this case because every single state in the court or every single court in the state of Vermont has been served notice and they've failed to address this issue. This is how you exhaust your state remedies. This is how you get into the Supreme Court, right? Is by notifying all of the opposing party and making it so that there isn't a court in the state that can oversee this. And so now we've got 47 states served. All the Supreme Courts, all the attorney generals, all served with their notice, all given a year to cure and remedy this, and they failed to do so. And that means that in those 47 states, not one single court in that state can actually oversee this case because they're all now opposing party to this case. Same can be said now with legislators. As we start bringing the legislatures in, right? None of the legislatures can claim that they weren't aware of this seditious conspiracy that exists. They've been informed. We've notified them. We've told them that there are laws that are in place and that they are paying people to break the Constitution under those alleged authority of the state statute. And when they fail to take action, then they are also a part of the criminal conspiracy. And now they're all enjoined. So the point is that this takes a long time to get to where we're at. This is a lot of work, you guys. It's a lot of work. I've been at this for 9 years on this one case, this one issue for 9 years. It takes a long time. And, you know, it takes on average about 12 years to get to the Supreme Court for those few cases that actually do it. We're at 9 years. So we're way ahead of the curve right now. Way ahead of the curve. All right. And we're going to get there. We're going to get there. Guys, we're going to get there. Right? Because under Civil Rule 60B4, where I opened up, you guys, remember, going back to jurisdiction, a court, in order to render a legally binding decision, it must have subject matter jurisdiction and it must have personal jurisdiction. Subject matter jurisdiction is removed the moment that they commit a crime. If government commits a crime, they lose subject matter jurisdiction, right? If the court was engaged in a criminal act, right, the court loses its subject matter jurisdiction, can't oversee it anymore. So there's issue number one, but issue number two is the court doesn't have personal jurisdiction because the court can't oversee the court's own case. The state can't oversee the state's own case. And as a result, they've lost personal jurisdiction, which is the right to oversee the parties involved in dispute. The state cannot oversee the parties involved in dispute when the state itself is a party in the dispute, because no man can oversee their own case. But under Civil Rule 60B4, which again, going back to where we opened up at, a judgment is either valid or it's void. It's valid in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If the court lacks either one of those two things, what it produces is void, wholly, without force or effect, as though it never even existed, because the state cannot obtain jurisdiction. The court cannot obtain jurisdiction when it lacks jurisdiction, and any judgment or action or decision rendered by a court that lacks jurisdiction is void. And that void judgment or that void action can always and forever be challenged. Right? Always. There is no statute of limitations on a void judgment. If the state does not have jurisdiction to oversee its own case, right, then that means that even if it's been a year and they say, oh, you can't come back and challenge this, yes, you can. You can. Because that judgment cannot become valid because it was unconstitutional from the beginning because the court did not have jurisdiction to do what they did, right? Problem is that it's the path that you guys choose to get there. It's an appeal versus a habeas, right? Appeal is collaterally attacking the judgment. That's the end. The habeas attacks the beginning and says, did the court have the authority to be a court? And if they didn't, then the detainment was unconstitutional, was unlawful because it derives from the unlawful act. So the habeas is the path that you have to take, right? You can't collaterally challenge the judgment because there can't be a judgment. Judgment's about when you go to the appeal, you're validating the judgment. But So going back here to the jurisdictional issue. All right, guys. When you guys want to, if you guys want to understand why our founders wrote the Constitution the way that they did, right? Why James Madison, drafted the Bill of Rights the way that he did, or the main body of the Constitution the way that he did, or why Benjamin Franklin or Alexander Hamilton or John Jay or any one of these other founders that drafted the Constitution. If you want to know why the Constitution was written the way that it was written, we will always go to what's called the Federalist Papers. Federalist Papers. The Federalist Papers is the record that we have of the founders. It was three of them, right? John Jay, Alexander Hamilton, James Madison. And it was the founders, it was articles, newspaper articles that they were writing to try to justify the Constitution and try to convince New York in particular that they needed to pass the Constitution so we could get it ratified and adopted, right? Because there were a couple states that were standing back and saying, no, we're not going to do this, right? So if we want to know the rationale behind the Constitution or any of the provisions, we would go to the Federalist Papers, right? And we would usually start there. And remember, conservative justices are typically what's called textualists or originalists, okay? Textualists or originalists. They're textualists because what they do is when an issue is brought to the Supreme Court of the United States, right? When an issue is brought, then they look at the intended purpose at the time of the adoption of the Constitution. So they look at the original intent, which is why they're an originalist, or they'll look at the text of the Constitution, that's why they're textualists, right? They don't bring in other outside influences such as, well, this is the way we've been doing it for 200 years, therefore, it's valid. No, it's not. If the original intended purpose was this, then a textualist court will rely upon the text or the original intent of the Constitution to make their decision. This is important because we have a conservative court right now, right? Do we not? 6 of the justices are conservative. And I'm not saying that's necessarily a good thing, but it certainly is a good thing for our efforts, right? If they are originalists, if they are textualists, such as Gorsuch, Barrett, Roberts, and Thomas, right? If they are and Alito and Kavanaugh, if they are originalists, textualists, then they would side in favor of this issue. Absolutely. Now, the non-textualists would be Jackson Brown, would be Sotomayor, would be Kagan. But the good thing about them is that they represent disenfranchised groups of people. So even though they wouldn't be originalist or textualist justices, they would be in favor of this. In fact, Jackson Brown has stated in rulings already, dissenting opinions, that she's tired of the court's no-see-em doctrine with regard to considering the innocence of prisoners. She's already stated that she would accept something like this. So even the non-textualists would be in our favor on this issue. Absolutely. Because once again, they represent disenfranchised groups, demographics of our population. Sotomayor being Hispanic and Jackson Brown being black. And so those are overrepresented groups of people within the justice prison system. And so both of them would be much more likely to side in favor of this in addition to the textualists. But that being said, if you want to know the original intended purpose of the Constitution, we would go to the Federalist Papers, written by John Jay, Alexander Hamilton, and James Madison. And I want to go back to this because I've said this numerous times, but I want you guys to hear once again. James Madison was the father of the Constitution. He wrote the Constitution. He wrote the Bill of Rights, the first pass at it. In fact, United States Supreme Court Justice Gorsuch, he says that James Madison is the authority for all things textual of the Constitution. They would always go to James Madison's writings to determine what was the original intent of the provision because he was the father of the Constitution. So what did James Madison have to say about the Article 3, Section 2 original jurisdiction provision of the Constitution? Again, what it says is in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Okay? So in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Let's break that down real quick. Original jurisdiction means that it's the court to act first. No other court can act before the court that has original jurisdiction. Okay? So a state doesn't have original jurisdiction if a state is a party, because the Constitution says Supreme Court of the United States has original jurisdiction if the state is a party. 1 second here, let me wipe this. Looks like you're a little bit smudged up here, Facebook. See if we can get that image a little bit better there. So the court that must act first is the court of original jurisdiction. Original jurisdiction. No other court can act before the court that has original jurisdiction. But that would mean that if the state does take action, right, what it's doing is it is taking jurisdiction of a case in which a different court has jurisdiction. If the Supreme Court has original jurisdiction, then no state can act in the original decision, right, because a different court has been statutorily imposed that obligation, right, by the Constitution. So original jurisdiction. Anytime the state is a part in the cause, the Supreme Court has the first cut at it, right? Because they have original jurisdiction. So James Madison wrote the Federalist number 10. Federalist number 10. And what James Madison said in the Federalist number 10 is he said, no man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So again, a body of men are unfit to be both judge and party at the same time. James Madison was pointing to the fact that the state is made up of a body of men. Okay? If that body of men comes at you as the accuser or brings an accusation against you, then that same body of men cannot be presumed to be neutral and biased to act as a judge against you. Therefore, a body of men are unfit to be both judge and party at the same time. James Madison was referring to the reason why he wrote Article 3 the way that he did. He was speaking about it directly in the Federalist number 10. A body of men are unfit to be both judge and party at the same time, right? Okay, so James Madison, the father of the Constitution, the main drafter of it, right? He wrote in the Federalist number 10 that a body of men, a state, cannot be both accuser and judge at the same time. Thus, Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. The state cannot have jurisdiction of its own case when the state is a party to that cause. Okay? Now, there's another founder who wrote in the Federalist Papers as well. That was Alexander Hamilton. Alexander Hamilton wrote the Federalist number 80. Number 80, right? And in the Federalist number 80, Alexander Hamilton made two references to this Article 3 issue. Two references. The first thing that he said is he said, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. Listen again. That the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. Federal judicial authority of the Union, right, which is federal court, right? But we're not talking district court, because at this point, the federal judicial authority of the Union was only encompassed the Supreme Court of the United States, right? So the federal judicial authority of the Union, the United States Supreme Court, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between a state and a citizen of the state, or the citizens of that state, then the federal judicial authority of the Union must extend. Thus, Article 3 says, in all cases in which a state shall be party, the federal judicial authority of the union must extend, right? The Supreme Court shall have original jurisdiction, okay? So the state cannot have jurisdiction of its own case because the federal judicial authority of the union must extend all cases between a state and the citizens thereof. But Alexander Hamilton made another statement in the Federalist Number 80. Not just one, but two of them. And what he said in the Federalist Number 80 also is that state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in their own cause or in any cause with which they have the least bit bias or interest. Okay, again, this is conflict of interest. Remember, James Madison said that their interest will most certainly bias their judgment. These are references to conflict of interest because James Madison said that their interest will no doubt bias their judgment, as well as Alexander Hamilton saying that no judge should be involved in any case with which they have the least bit bias or interest. Conflict of interest. All right. But again, what Alexander Hamilton said in the Federalist Number 80, state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in their own cause or in any cause with which they have the least bit bias or interest. Straight tribunals cannot be presumed to be impartial when they speak for themselves. Okay? State court cannot be presumed to be impartial when it is speaking in its own case, on its own cause, because of the conflict of interest that exists. So now we have two of the three authors of the Federalist Papers who made references in the Federalist Papers directly attesting to this issue, this conflict of interest that exists, and why our founders wrote the Article 3 the way that they did, that assigns original jurisdiction anytime the state is a party to the United States Supreme Court. But the third author of the Federalist Papers was a man named John Jay. John Jay didn't write anything in the Federalist Papers attesting to this, right? But he did go on to become the first United States Supreme Court Chief Justice, okay? So he didn't write in the Federalist Papers anything having to do with this issue, this conflict of interest, but he did in a case called Martin versus Hunter's Lessee. Martin versus Hunter's Lessee. And what he said in Martin versus Hunter's Lessee is he said that the Constitution has presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. Again, it is the case and not the court. So what he's getting at here, once again, is he said that the Constitution has presumed that state attachments, state prejudices, state biases might from time to time obstruct the administration of justice by state judges. He's saying that state judges are going to advance their own state interests because they're an agent of state. And the Constitution has presumed that this would happen. Therefore, it is not a state that grants jurisdiction to the Supreme Court. It's not a state court that grants jurisdiction to the Supreme Court. There's no remedies to exhaust because it is the case and not the court that grants jurisdiction to the Supreme Court. It is the case and not the court because the Constitution says in all cases in which a state shall be party. The case is made up of two parties, a state and a person, right? Or a person and a person. The state is made up of two sides, a moving party, responding party. That is the case. Therefore, it's not a court that grants jurisdiction to the Supreme Court. You don't have to go exhaust any remedies because no court grants jurisdiction to the Supreme Court. Only the case grants jurisdiction to the Supreme Court because the Constitution, again, says in all cases. And when the case is created, right? When the case is assigned to Chris, right? When it is set up and established, it is state of whatever versus you. State is a party. That means state lost jurisdiction. There's nothing that state can do as of that moment that can give them jurisdiction. Everything that they're doing from that moment forward, from the creation of the case on, is all void, wholly without force or effect. That includes the arrest, That includes the investigation, that includes the bench trial, the jury trial, the plea bargain, the sentencing, the fines, everything. It's all void because the moment that the state took action in a case, took a side in a case, that state no longer has jurisdiction over that case. And the only court that did have lawful authority to oversee it is the United States Supreme Court, in accordance with the United States Constitution, upheld by James Madison, Federalist number 10, upheld by Alexander Hamilton, Federalist number 80, upheld by John J. Martin versus Hunter-Leslie, and also upheld by the Federal Judicial Code for automatic recusal. The automatic recusal code, Title 28, USC subsection 455 says that a judge has a mandatory, non-waivable, self-executing duty to recuse himself if he is an officer of either party. This is the exact words. Go out and read it. An officer of either party. So if you are a judicial officer of the state and the state is a party in that cause, you have no lawful constituted authority to be able to oversee it because you have a mandatory, non-waivable, self-executing duty to recuse yourself because of the obvious conflict of interest that exists in that case. You cannot be both judge and party in the same cause, right? So when the state brings an accusation against a person, then the same body of men that represents the state cannot oversee the disposition of that dispute. And that is the heart of this litigation. That is what we're fighting, right? That's what we're dealing with here. So once again, if you consider the indictment issue, we're using the indictment issue because it's clear. It's enumerated, it's written right there for all to see. It's an easy argument, right? Very, very simple. So when we look at the indictment issue, that's easy. That gets us into the court, right? Because today we have more than 700,000 people that are currently being held by states who have failed to follow the very, very basic enumerated procedures and processes codified in the Constitution for the adjudication of a crime. Tell me that's not a big deal. Tell me that's not something that we're going to be able to get the attention of the people of the United States if we stay at this, right? Why does the Constitution say that you have to do this, state of California, and you chose to not follow the Constitution of the United States, right? Once again, this goes back to the states that are refusing to follow the Constitution of the United States. They're saying, oh, it doesn't apply to us, doesn't apply to our courts. We have states' rights that allow us to be able to do what we want. That is not true. Right? It's not true all the way around, but I'm gonna tell you the reason why it happened, why we're where we're at today. But before I do that, I want to say that constitutional law, subsection 171 says state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. Right? State courts and federal courts are equally obligated to guard and enforce every obligation secured by the Constitution. So the state courts are not at liberty to be able to abridge their constitutional obligations. In other words, create a law that's contrary to the Constitution, then go out and enforce it, right? They don't have that authority. We also know from the Constitution itself, the Supremacy Clause. If the Supremacy Clause, if the states had the authority to be able to not follow the Constitution, then why does the Supremacy Clause say this Constitution and the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state contrary notwithstanding? Why is the states even mentioned, right? And more importantly, why does it say that the judges are obligated, are bound to enforce anything in the Constitution? You see, the Supremacy Clause, again, it says the judges in every state are bound to enforce anything in the Constitution or laws of any state contrary notwithstanding. Is the Bill of Rights part of the Constitution? Yes, it is. It was adopted and ratified on December 15th, 1791. In all intents and purposes, it is part of the Constitution. Okay, then that means that the judges are obligated to enforce the Bill of Rights. Okay, Can the judges disregard that? No, they can't, because it says the judges in every state shall be bound thereby anything in the Constitution or laws of any state to contrary, notwithstanding. Judges are obligated, right? This is a duty that they have to guard and enforce every right secured by the Constitution. So when a judge in a state decides that they're going to follow a state statute, they've just abridged their obligations, the United States Constitution, because the judges in every state shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding. It was adopted and ratified by the people, became part of the Constitution. The states must adhere to it. To what other purpose is the Constitution than to bind the states to certain limitations of power? Doesn't make any sense, guys. But the reason why we're where we're at today is because of a case called Barron versus Baltimore. This is from 1833. It was the Marshall Court, right? But what you need to understand is the Supreme Court of the United States has not been making decisions that's in the best interest of the people. Barron versus Baltimore wasn't the right decision, right? But what Barron versus Baltimore said is it said that the Bill of Rights, which are the first 10 amendments to the Constitution, that those are not a restriction against state governments. It is only a restriction against the federal government. In other words, the federal government has to give you your federal constitutional rights, but the states do not, right? They do not have to give you your federal constitutional rights. So that would mean that you could be living in Louisiana, but you don't have the freedom of speech, right? Because the state isn't going to give it to you, right? That would mean that you could be living in New York, but they say, you better not be a Baptist, otherwise you're breaking the law. That would mean that you could be in California, but you don't get a trial by jury. California says, well, we don't want to do it, right? That would mean that you could be in Wyoming, and you wouldn't have the right to peaceably assemble to stand up against your government and their oppressive and tyrannical acts, because the state doesn't want you to. If the states were not bound to enforce the Bill of Rights, then all of these freedoms that the people of the United States believe that they have in every state wouldn't have any of them. State of Connecticut does not have to give you freedom of speech. State of Michigan does not have to give you the right to bear arms. The state of Louisiana does not have to, not impose excessive fines upon you. Those are all contained within the Bill of Rights. So when the Supreme Court of the United States comes out and says, Bill of Rights doesn't apply to states. States can do anything that they want to their people. You only get those rights under federal court, because only the federal government is obligated to enforce them. You see, such a statement is intentionally undermining the Union. It's intentionally undermining the Constitution of the United States of America. And it's removing and destroying the rights of the people. It's a horrible, horrible thing to think. That according to the United States Supreme Court, I don't have the freedom of speech anywhere. Because if the state doesn't want me to have it, the state doesn't have to give it to me. So again, in 1833, United States Supreme Court comes out and they make that ruling. That's the ruling they made. Bill of Rights doesn't apply to states, only applies to the federal government. They didn't make that for the right reason. They made that because it was to preserve and advance their industry, right? The decisions that the Supreme Court makes is not in the best interest of people. So what was going on during this period of time was 1833 was when the first national bank was established. First national bank. Again, bank, right? So the first national bank was established in 1833. Well, the government, federal government in particular, knew that the states were going to sue. Right? The people of the United States did not want a national bank being put into place because the people knew that debt was the greatest and easiest way to enslave a nation. We knew that from our own time with Britain and England. So we knew that the states were going to sue if they established a national bank. So they needed to find a way to keep the states from being able to sue right? Once the national bank was set up. So the Supreme Court of the United States was brought in to pave the way for the national bank to be established so that the federal government could start collecting money from the states through taxes and other things. And the reason why is because to sue in federal court, you have to be two things. You have to have two things. One, you must be a person, or in this case, this is the body of people, the state, right? And two, you you have to be directly impacted by the law in question. If you are not directly impacted by the law in question, then you do not have standing in federal court, right? And you can't bring a suit to court. So basically what the Supreme Court said, and the reason why they made the decision in 1833 in Barron versus Baltimore, was because they knew that the states were going to sue. But if they say Constitution doesn't apply to you states, then the states did not have standing to be able to sue in federal court once the First National Bank was established. And that's what they were doing. It's exactly what the court did. The court paved the way for that First National Bank to be established. They were working with the legislators, right, to establish National Bank so that they could eliminate standing so that the states would not be able to sue. And what they said was the Constitution doesn't apply to you states, therefore you don't have standing in federal court. 6 months later, they established the First National Bank, and there was no standing for the states to be able to sue. And thus, the purpose of Barron versus Baltimore was not to, establish truth and justice and say, yeah, the states, the Bill of Rights doesn't apply. No, it was just simply a way of them advancing their industry, right? And being able to tax the states without the states having standing to be able to sue back and say, no, we don't want that. But that's what we're still dealing with today. I just had someone just yesterday or the day before come out talking about Barron versus Baltimore and how because of Barron versus Baltimore, I'm wrong and everything I'm saying is bullshit, BS and whatever. That's not true. I mean, because the Bill of Rights does apply to states. Because once again, does the Supreme Court have the constituted authority to be able to amend the Constitution of the United States? And they don't. But Barron versus Baltimore did just that. Barron versus Baltimore said, states, I understand that the Supremacy Clause says that this constitutional laws of the United States are the supreme law of the land, and they enjoy legal superiority over any conflicting provisions with state constitutions and laws, and that the judges in every state shall be bound thereby anything in the Constitution or laws of any state to the contrary notwithstanding. We understand all of that, but they came in and said, we don't agree with that, right? So states, you can do whatever you want, right? Because otherwise you would be bound and limited and you would have standing federal court to be able to sue. Once again, like Article 3 of the Constitution, where it says, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where in which the crime is said to have been committed. That means that the original intentions of the Constitution of the Founders was that the state would adjudicate criminal matters. It would be the state that would be the judge, because the trial of all crimes shall be done in the state in which the crime is said to have been committed. So our founders called out the state as the judge in the case, right? They were supposed to oversee the case, right? So if that's true, then why would the Bill of Rights, which provides the limitations of power, the protections of criminal defendants, right? You can't be arrested, you can't be searched, you can't not have a trial by jury, you can't have cruel and excessive punishment, you can't have excessive fines. I mean, all of the protections of criminal defendants is all contained within the Bill of Rights, and yet Article 3 says that the state was the place where the crimes were being adjudicated. So why would the restriction against the states not apply, or why would the protections of criminal defendants not apply to states when it's called out right within Article 3, and then the protections preserved within the Bill of Rights? Guys, this doesn't make sense. It doesn't make sense what people are saying to you. And what I would say is that when you guys see something like that, someone coming out and saying, man, he doesn't know what he's talking about, right? The Bill of Rights is only restriction against the federal government. I would welcome you guys to go ahead and just ask them, well, are you for the Constitution or not? Because if you're proposing that the state doesn't have to follow the Constitution, then I would say that you're kind of anti-American. You're kind of anti-Constitution, right? Because you're saying that the Constitution doesn't, I mean, what we are arguing here can't be any more American, right? Can't be any more based upon our founding principles, right? The Constitution was limitations of power to protect the individual liberties of the people, right? All we're doing is saying, this is what the Constitution says. States, why aren't you doing it? And anybody that comes out here and says states don't have to do it, right? That's stupid. Well, those are people that don't support the Constitution of the United States of America. Those are people that are promoting and progressing the destruction of the Union. And those are not people that I want in my, on my follow list. So anybody that would argue what we're arguing here, they need to take an honest look at themselves, because there isn't much more anti-American than refusing to acknowledge the supremacy of the Constitution of the United States of America, and then, offering that states have got the power to be able to destroy it through inferior legislative practices. Can't do that, right? Can't do that. I was watching that 60 Minutes show about CCOT, right? And what's going on with CCOT, so I don't know what you guys know about it, but they did run the pirated version through the Canadian app when 60 Minutes refused to run the program about the abuse of the prisoners down in El Salvador at CCOT, CECOT, CCOT prison. And when I watched the video, it actually brought up a whole bunch of my memories of my time with intelligence and with government. You guys remember, I used to work for intelligence, right? And I used to work for Department of Energy and Homeland Security, and I was very high up in a lot of these programs. And the history behind the war on terror was that what happened was September 11th, we had a lot of knee-jerk overreactions. And it was the result of the traumatic events that occurred that we couldn't fully understand. And so what happened was that the Patriot Act was established, and we allowed for the erosion of our constitutional rights in favor of governmental protection. Right? Government, protect us from these unknown, threats that exist that we just don't want to have to deal with. That was what was happening after September 11th. But so if someone called up government agency, Homeland Security or CIA or something else, and they said, this person is a terrorist, well, they would take a single set of allegation, right? That would be it. One allegation would come in. We didn't verify the allegation. We didn't make sure that it was truthful. We didn't give the accused the opportunity to confront the hearsay accusations against them. We just simply said, here's the truth. And then we would go out and we would find them, right? Remember Bush's playing cards, right? Those were all identified enemy combatants. So we would take those enemy combatants, right, once we found them, and we would bring them down to Guantanamo Bay, Cuba. And we put them into a facility there called Camp X-Ray. And the reason why we brought them there was because it's not part of America, right? It's not in the jurisdictional United States. It's not in the territorial United States. Therefore, we can bring them there, and we don't have to give them due process of law, right? A lot of this should be ringing a bell right now, right? But we brought them there because they were not subject to the Constitution because they weren't in the jurisdiction or territory of the United States. And so we were bringing them there based upon a single allegation made by someone that this person is a terrorist. And we just say, okay, well, that's what he is then. And we would put him in his facility. We would not give him an opportunity to confront the hearsay accusations against them, right, which is constitutionally required, called a grand jury. We would not give them right to counsel, right, which was also in the Constitution. We would not, search and seizure didn't exist because just take them and whatever. We would hold them there, during extended periods of time. There's no speedy trial. We would put them through horrible, what's called deprivation tactics, which are tactics that are intended to mess with you physically, sexually, and emotionally, to get you to comply with the abuser, torturer's, intentions, desires. So if we wanted you to admit that you were a terrorist because we have the evidence on you, someone said you were, therefore we know you are, then all we would need to do is put them through deprivation tactics, and it doesn't matter how strong they are, they will eventually admit that they are what we say that they are. It's only a matter of time. Waterboarding, hot and cold heat fluctuation, sleeping on concrete floors, dark boxes with no light. All of these things are all deprivation tactics that our government employs. And this has been employed for thousands of years. Like we aren't the current terrorists, but these tactics have been used for thousands of years. The delivery might be slightly different, but the intended effect remains the same no matter what. But this is what we did. Now, this was during the War on Terror. So we're talking about, 2002 to, 2000 and whatever, 2016 roughly. We were doing this, Guantanamo Bay. And, but what we know now in hindsight is that most of the people that we sent to Guantanamo Bay, they were not a terrorist when they got there, but they were when they left. This is well known, right? A lot of those people were not terrorists when they got there, but they were when they left because of the tactics that we were employing on them, right? We would bring them in and we would abuse them sexually, mentally, physically. We would hurt them in order to get them to comply with our belief. You're a terrorist, we know you are, therefore we're going to do these things until you agree that that's what you are. And so, again, we were doing that because that was justifying our war on terror. Many of the people that went to Guantanamo Bay were not terrorists when they got there, but they were when they left. So we were actually creating the very object that we were going out and fighting against in order to justify this war on terror. That's what we were doing. Now, whether our government knew it, I can say that I certainly didn't know at the time that that's what we were doing. I believed and I bought into it. I'm like, we got to do this because otherwise we're going to have these people coming and attacking us again and killing our people once again. These knee-jerk overreactions that we had resulted in our willingness to give up, those things that are most sacred to our country, the freedoms that we hold dear. And we were giving them up because of this fear that we had, right? Under this terrorism umbrella. But being in national security high up for many, many years, I've come to understand that national security is simply code word for domestic terrorism. We are not to protect the government from the people. We are to protect the people from government. And I was on the wrong side for many, many years. I was fighting for the wrong side. And I was building solutions and technology and practices that were actually harming the people, in the name of national security, right? Justice, or whatever we want to call. So what was going on in Guantanamo Bay, those tactics that we use, one of the things that I learned early on and that really opened up my eyes is that the exact same tactics that we were using in Guantanamo Bay are used in every single jail and prison across this country every single day. They're used to get people to comply, right? If they want you to plead guilty because they know that you're a criminal, they got the information on you, they got the accusation, and they know that you're a criminal, then they're going to use those deprivation tactics as a mechanism to get you to admit that you are in fact what they say that you are. They're going to lock you up in a dark box, right? They're going to put you in an abusive environment. They're going to leave the lights on. There's going to be hot and cold heat temperature fluctuations. You're not going to have a better mattress to sleep on. It's going to be extremely uncomfortable. They're not going to feed you enough food because, you know, if you're worried about where you're going to get the next meal, you're not worried about how am I going to overcome this oppression that's come upon me. All of these are all deprivation tactics that's designed to get you to comply with your abuser. And that's exactly what's happened here in America. All of these prisons that we have or jails, they're all used to get you to comply with your abuser's desires. But now this video, right, this 60 minutes thing with CCOT, it brought back some really bad memories about what we were doing in Guantanamo Bay. The exact same thing. I mean, this El Salvadorian prison is nothing more than Camp X-Ray. I mean, it's the same thing. It's like history repeating itself all over again. And the government's going to come with the same argument that, oh, it's El Salvador. We outsourced all of this now. It's not our CIA that's doing it. It's them that's doing it. Nonetheless, our government is paying for these things to happen. And why do you think that they're paying for it? Because history will tell us that when America abuses people that are not criminals, those people become terrorists. And that justifies our war in wherever, Venezuela or South America. We take Venezuelan people and put them down there, abuse them, torture them. Even if they were not a terrorist when they got there, they will hate America when they leave there. And now we have the same thing that we needed to justify our war on terror after 9/11. I mean, this is the same exact playbook that we had back then, and it's frustrating because I see a lot of these people, you know, that video. A lot of these people are they're not dangerous, but they will be once this government gets done with them, because of the deprivation tactics that we're employing on them. That's going to hurt them, and in hurting them, we're going to make them into the very object that we need them to be in order to justify our war on whatever, Venezuela. It used to be the war on terror, but now it's going to be the war on something else. And so it's not a good thing. But you guys need to look at the history of Guantanamo Bay and how that compares to what's happening right in our face right now with the CCOT stuff, and how we are literally sending people that are not violent to a very, very violent place so that they can learn how to become violent, so we can justify our doing so to them. And whatever they do to us is, would justify our response. It's scary because it's the exact same playbook that we had in Guantanamo Bay. The last thing I wanted to mention here was, Jessica and I, we had a conversation the other day about banks, right? And I just want you guys to think about this, right? Because I think that most of us understand the banking scam that exists, right? So the Treasury, everything that's in the Treasury is the people's money. Like that's ours. I personally own 1/330 millionth of the value of the United States of America. I have that. That value is then in my SESQB or whatever. It's in my Treasury account. I have a certain. I'm worth a certain amount of money because I am personally an owner of America. And the value of America is stored within the Treasury. So when I go then and I want to purchase a car, for instance, I use my Social Security number and I go to a bank and I give the bank my Social Security number, and then that bank will then use my Social Security number to go to the Treasury and say, Treasury, he wants to purchase a vehicle, and they'll say, well, we need, $20,000, and that's what he's asking for is $20,000, and then the Treasury will then issue a check to that bank, and then the bank will use that check to give me the money, right, But as I was thinking about this, right, all of that makes sense. It's bullshit, right? That the money that we get comes from our account. You know, it's not the bank's money. The bank is just simply the middleman, and you know, all of that is true. It's not. It's unfair. But what we were talking about specifically was, if I have to pay back the money that the bank loans to me, that money should be put back into my account, right? It should be put back into my treasury account. But that's not what happens. The bank keeps the money. So let's run through this scam. First, I have money contained in my account. I need money to purchase a vehicle. That money is then created out of thin air, right? Through the treasury. Treasury then creates money, pulls money out of my account, gives it to the bank. Bank says to me, here's money, go buy the car. I buy the car, but I have to pay the bank back my money, right? Plus interest, and then that money sticks with the bank. The national debt would be reduced if the money were put back into the treasury, but it's not. The bank keeps money. So not only do they steal or use our money to give it to us, but then they steal the money from us, require us to pay interest, and if we miss a payment, they're going to take our property as well. This is the biggest scam I've ever seen. Like, that money should be being put back into the people's account, and it doesn't. And as we thought about that particular one, there is a lot that people can do. I mean, this is not some litigation that I want to get involved in, but I'm telling you what, the fact that the money, right, the money, there is no equitable return, because the money that we have, our money, is given to us, and then we're required to pay that money back, and that money should go back into our account, thus reducing the treasury. But instead, the banks keep that money, right? Which means that they just stole all, the whole amount. The money is taken from our account, and then the bank just steals it, keeps it. Requires us to pay it back, which there is no damage to the bank. They're not damaged in that. Again, the only damage that the bank could have would be the absence of the interest payment. But the bank is keeping all that money anyway. Every single payment you make, like, is not going back in the account. It's going into that bank's coffers. And so those of you that are dealing with those issues, there's a real claim there. If you guys want to step in and argue something there, there is no equitable distribution. So, all right, guys, I'm going to step up. I'm going to step back upstairs. I'll read some of these and reply as necessary. Again, if you guys want, get onto Jessica's live. She'll be doing it for probably 3 more hours. That's part of the reason why I'm down here. But if you guys need, you go to justicewithoutlimits.org, and the Zoom information is there. Get on and listen to what she has to say about serving the county commissioners and city councils. We have a couple tomorrow that we're doing in a new state that we haven't done yet anything in, no parliamentary services. So we're going to be out tomorrow. There is some stuff that we might be able to do on Tuesday, maybe as far as Kentucky, but then we're stuck for the rest of the week with the holidays. So, and then we are in DC January 5th through the 9th with Toll and Roll. And then after Toll and Roll, we're going to be heading back up north. We have to drop some stuff off in New York, and then cutting across the state. And we're starting another Western loop at that point in time. So we'll be back over. We got to get some Oregon done. Want a little bit more done in Montana. We haven't done anything in Wyoming yet. Both the Dakotas, we haven't done any parliamentary services. So So we're gonna head across the top of the country, hopefully before too much snow hits, and that way we're not driving, later on. So that second week in January, we'll be crossing over the top of the United States once again, heading back west, and then we'll probably circle around into the south for the bulk of the winter, trying to get caught up. We haven't done any parliamentary services in Louisiana. We haven't done any in Mississippi, so we need to get in there and do them. We did just do our first Arkansas, and we've done I think 2 Tennessees. So we're doing what we can, guys. Okay. We were also invited into West Virginia to serve the commission in Kanawha County, which is the capital, Charleston. So as soon as we know the date on that, we'll be over there to get that done as well. All right, West Virginia, we haven't forgotten about you, and that leaves only Hawaii and Alaska left to serve. All right. So there's still a lot of scammers out there. I'm going to say this again because apparently some people just aren't getting this. We will never contact you asking you for money, ever. You will never receive a message from me or Jessica asking you to pay us for our services, because we are not attorneys and we're not solicitors. So if you get a message from someone saying, hey, we would love to come and help you on your case, that person is a liar and a thief, because that's not coming from Jessica or I. They might use our picture. They might have stolen my logo. They might have a Cash App that's real similar, right? But it's not us, because we operate on donation only. Donation only. We do not solicit for work. We don't offer to come. You guys don't want us there anyway, right? Because the most dangerous place for us to be would be walking into a courtroom of a state where they can arrest us for practicing on a license or whatever else. What we're doing is we are serving, right, the agents. That is not a function that's a role that's traditionally performed by attorneys. We're not practicing law. Collecting affidavits is a role that's done by law enforcement. I'm law enforcement. That's what we're doing. Collecting affidavits and serving notices for crimes being committed. That's not role that the attorneys play. We are not. Neither Jessica or I will ever walk into your courtroom and help you with your case, because that is a sure way to get us hemmed up. You guys don't want us doing it, right? Okay? We're not going to do that. Not only that, but the jurisdictional issue addresses all of your cases. If it's a criminal matter, the state was a party in the cause. Jurisdiction eliminates it. Doesn't matter where you're at in the case, whether they're getting ready to sentence you, the sentencing is void because the state didn't have authority to do it, right? I don't have to come and argue an individual case. I don't have to fight an individual case, because this issue resolves all issues. Same thing with CPS. Like, we don't have to go down and fight in a local court on a CPS issue, because this jurisdictional issue will address all of it. It's all addressed by one single issue. And that is, does the state have the authority to be both accuser and judge in the same cause? And the answer is no. CPS, that resolves it. Criminal matters, that resolves it. So once again, neither Jessica or I will ever contact you asking you for money. We will never offer exchange of services. And so if someone messages you asking for that, I have to say, please don't blame me if you guys donate them money, okay? There's people that are still donating hundreds and thousands of dollars to these people, and I've seen the messages. It's so I don't know how many more times I can say that. This is the We Shall Be Free tour. If you want to donate, it's We Shall Be Free. Cash App, Chime, Venmo, PayPal, that's the only way to do it, okay? There's no other way. So if you donate to any other source, or if you believe that we're coming to your town to look at your case and to fight for, it's not us. We are not solicitors. We're not soliciting for work. We're not, okay? We're out here. We're serving on your behalf, speaking on your behalf as advocates normally would. So if you do want to donate, you can go to the website, justicewithoutlimits.org, and the donation points are there. If you don't want to go there, you can also go to Cash App, Chime, Venmo, and PayPal, and they're all exactly the same. We Shall Be Free. It's WESHALL BEFREE. We shall be free. There's no other way to donate. No other way. So please, if you guys get scammed, don't get mad at us. Okay? You guys, you're gonna have to make sure that you guys are donating to something legitimate. Because if you guys get scammed and then you come at me and you're mad at me because of that, I'm just gonna block you. And I'm sorry, but you know, you're not gonna come and accuse me of stealing from you when I have been very, very clear over and over and over again that this is the only way that you could donate, and we will never, ever, ever come and fight your case for you. We are not an attorney. So please quit donating to these scumbags. And if you do, or if you have, please call up your Attorney General, Consumer Protection Division, and report the crime, okay? Report it. I can't report it, but you can. If you've had money stolen from you from this asshole, go to the Attorney General's website, go to their Consumer Protection Division and report the crime. I would love to get these people caught, right? I would love to get them to stop stealing from you, but I can't control that. I can't control. They had a driver's license. They had made a little fake driver's license. It was supposedly Jessica, and they were sending this little fake driver's license out saying, yeah, this is proof that it's me. You're really talking to Jessica, right? Well, that driver's license, one, was from Washington, and Jessica's never lived in Washington. Two, it said that her address was Washington, D.C., even though it was a Washington state driver's license. It also said that she was 6'2", 180 pounds, and that she was a veteran. You guys, come on, you got to use some common sense here, okay? Jessica's definitely not 6'2". She's definitely not 180 pounds. She's not a veteran. The address is Washington, D.C., not Washington State, right? And yet this person has gotten thousands of dollars even by doing that, trying to make. So you guys, you got to use some common sense here. And you guys got to look at that. Why would anybody send you a photocopy of their driver's license to prove that they are who that they say that they are? All right, just get on the phone with them, right, and talk to them. If it's me, you'll know that it's me. Which brings me to my point here is that I only have one telephone number, and it is a 202 area code. 202 area code. That's it. I have no other phone number. For those of you that know my phone number, right, you know it. If you know, you know. Otherwise, if you don't, the only number I have is 202. I'm from Washington, D.C. I'm not from 520. I'm from Washington, D.C. 202. There's only 202 and 771. Those are only two phone area codes that apply to Washington, D.C. So I have a 202 area code number. Jessica only has one phone number, and it's a 252 number. If you know, you know. Right? 252. So if anybody's contacting you from any other phone area code, once again, it's not coming from us either. You guys got to use some common sense here, please. All right? Common sense. So I think that's it. Thank you guys so much. Praying for a good week coming up. And guys, we got this. We got this. We got it. We're fighting for the Constitution of the United States. The only argument anybody is raising at this point in time is that the states don't have to follow the Constitution. That's a loser for them. That's a loser for them. I will go into any court any day and fight that battle on behalf of people of the United States any day, right? Because anybody that has to say that to the people of the United States certainly doesn't deserve to be in a position of leading the people of the United States. So the only argument that any one of them has raised is that the states don't have to follow the Constitution. And again, that's a loser. It's a loser. You're not going to win that one. All right. So God bless, guys. Get on with Just Without Limits and the Zoom. And guys, have a good week, okay? God bless. Have a great rest of your night. Thank you, guys. Have a great rest of your night. Thank you, thank you, thank you. Have a great rest of your night, YouTube. Thank you. Or YouTube over here. Thanks, guys. Have a good night, okay?